I've been on this bench for 31 years. 31 years of watching people walk through those doors. Guilty people, innocent people, arrogant people, broken people, people who deserved better than what life handed them. I've seen crying that was real and crying that was performance. And after long enough, you learn to tell the difference pretty fast. But I want to tell you about the morning Garrett Whitmore Ellison III walked into my courtroom in his Italian loafers and his custom charcoal suit. And I want to tell you what I found out about 20 minutes after he sat down. Because what I found out changed the direction of that hearing so completely that the court stenographer actually stopped typing for a second. And in 31 years, I have never seen that woman stop typing for anything. This story has been sitting with me for a long time. I've thought about telling it probably a dozen times, and every time I thought, no, not yet. But enough time has passed now. The people involved have given me permission. And frankly, some things deserve to be said out loud. Garrett Whitmore Ellison III was 34 years old the morning I first laid eyes on him. He arrived 17 minutes late, which in my courtroom is not a small thing and is not an accident. People who show up late to court are almost always making a statement. His attorney, a man named Clifford Beaumont, who I recognized from half a dozen other cases involving families with more money than humility, walked in right behind him carrying a leather document case that probably cost more than most people in this building made in a week. Garrett had on a Vacheron Constantine watch, not a Rolex, a Vacheron, which I only know because my late husband, Gerald, used to have a thing about watches and once spent 20 minutes explaining to me why the Vacheron was what people bought when they wanted something even Rolex wearers would notice. The suit was bespoke. You can tell. The way fabric sits when it's been made for a specific body is different from anything you pull off a rack, no matter how expensive the rack. He sat down at the defendant's table without making eye contact with anyone and pulled out his phone. Set it face up on the table. Not face down, face up, as if he expected something important enough to interrupt these proceedings and wanted to be ready. His family occupied most of the first two rows on the right side of the gallery. His mother, Diane Ellison, was in a cream-colored blazer with a pearl necklace that I clocked immediately as the kind of thing that gets handed down, not purchased. His father, the senior Whitmore Ellison, the one whose name appears on half the commercial real estate in this county, sat with the still, composed posture of a man who had been in rooms like this before and had always come out fine. I've learned to recognize that posture. It's the body language of certainty, of someone who genuinely believes the outcomes of legal proceedings are, at some level, negotiable. The Ellison family's net worth at the time of these proceedings had been reported in the business press at approximately $1.8 billion. Their holding company owned 11 properties within 15 miles of this courthouse. I'm telling you this because context is everything. Garrett did not grow up in a world where no was the final answer to anything. And that upbringing was about to cost him in ways I don't think even his father saw coming. Now, let me tell you about the other table. Marcus Tatum arrived 8 minutes early. He was in his dress uniform, Army, Staff Sergeant, the kind of uniform that takes effort to put on correctly and more effort to wear with the posture Marcus wore it. He was 36 years old. The uniform fit across the shoulders but fell differently below the waist, and I noticed it right away because I've been doing this long enough that certain physical details find you without you looking for them. He had a wheelchair beside his chair. One of those lightweight manual chairs, the frame the color of brushed aluminum. He had transferred out of it to sit at the counsel table, and the movement had been smooth and practiced, the movement of someone who had been doing it long enough that it no longer required thought. Marcus Tatum lost both legs below the knee in Kandahar Province in 2011. He was 23 years old. He was running across open ground to pull 3 children, ages 4, 6, and 9, away from a vehicle that was about to detonate. He got all 3 of them out. He did not get himself out in time. His attorney, a woman named Priya Vasquez, who worked out of a 2-person office off Route 9, had brought a file folder that looked like it had been organized carefully and reorganized twice. She had on a dark blue blazer over a white blouse, and she looked like she had slept maybe 5 hours. She smiled at Marcus when she set her folder down, a small, real smile, and he nodded at her. In his right hand, Marcus was holding something. A small laminated photograph. He set it on the table in front of him, face down. I didn't know yet what it was. I would find out later. And when I did, I'd have to set my glasses on the bench and take a breath before I could continue. His mother, Erline, was in the gallery. She had on a church blazer, navy, with a small American flag pin on the lapel, and she had her hands folded in her lap, and she was watching her son's back with the kind of quiet attention that I can only describe as prayer. She didn't say a word the entire morning. She didn't need to. The case at its surface was a housing matter. Garrett Ellison, as the managing partner of Ellison Property Group's residential division, had initiated an eviction proceeding against Marcus Tatum 11 months prior. Marcus was renting a ground floor unit in a building the Ellison Group had recently acquired, a two-bedroom apartment in a building that was not fancy, but was functional and critically accessible. Ramp to the entrance, wider doorways, a bathroom that had been modified by a previous tenant who used a wheelchair. For Marcus, it wasn't just the cheapest available option. It was one of maybe 6 units in a 15-mile radius that would have worked for him physically without requiring renovations he couldn't afford. The eviction notice had been filed on the grounds of lease violation. The specific violation cited, Marcus had installed a grab bar in the bathroom without written permission from the property management company. A grab bar, the kind you put on the wall next to the toilet, the kind that costs $40 at the hardware store and takes about 20 minutes to install. The kind that, under the Fair Housing Act, a tenant with a disability has a federally protected right to install with proper notice to the landlord, provided they offer to restore the unit to its original condition upon departure. Marcus had submitted written notice of the modification. Priya Vasquez had the certified mail receipt sitting in that file folder. Dated 14 months before the eviction filing. No response had ever been received. Now, Garrett did not know I knew any of that yet. His attorney had filed a motion to dismiss Marcus's counterclaim on procedural grounds, and we were here to argue that motion. Garrett seemed to believe this was going to take 45 minutes and that he was going to win. He checked his phone at 9:22 in the morning, which was 4 minutes into the hearing. I stopped speaking mid-sentence. Strategic silence works wonders on people who think they're in control. I let the silence sit for what was probably 8 seconds, which in a quiet courtroom feels like a full minute. Garrett looked up. His attorney put a hand on his arm. Garrett set the phone face down. He did not look embarrassed. He looked inconvenienced, and the distinction matters. I said, "Mr. Ellison, in this courtroom, the matter before us is the only matter before us. Your phone is not." I let another beat go by. "Are we clear?" He said, "Crystal." Just that one word. Not "yes, Your Honor." Not "I apologize." Just crystal, with the intonation of someone who has been corrected by people he considers beneath him and has learned to absorb it without actually receiving it. Clifford Beaumont began his argument regarding the procedural motion. He was good, I'll give him that. He cited 3 cases, 2 of which were actually relevant, and he was moving at a confident clip. And then about 6 minutes into his argument, Garrett leaned over and whispered something in his ear. I don't know what it was. But Clifford's rhythm broke for just a half second, and then he pivoted to say something he hadn't said before, that the counterclaim should be dismissed in part because, and I'm quoting directly from the transcript here, the plaintiff's claimed disability accommodation needs have not been formally verified through proper channels in the context of this property and this lease. I held up my hand. I looked at Clifford Beaumont for a moment, and then I looked at Garrett, and then I looked back at Clifford. I said, "Counsel, are you telling me that the disability status of a decorated United States Army veteran, a matter of federal medical record, is in dispute in this proceeding?" Clifford said, "Your Honor, we are simply noting." I said, "I heard what you noted." Garrett at this point did something I don't think he meant to do out loud. He exhaled, a sharp, short exhale through the nose, the kind that in any other context you'd call a scoff, and said, just barely under his breath, "This is ridiculous." The gallery heard it. Erline Tatum heard it. I heard it. I did not raise my voice. I have not raised my voice in a courtroom in probably 12 years. I find that the lower I speak, the more people listen. I said, "Mr. Ellison, you would like to speak? Please, by all means, speak." He straightened. He said, "I just think this whole situation has been blown way out of proportion. It was a grab bar. We would have approved it if he'd asked through the right channels." Priya Vasquez said quietly, "He did ask, Your Honor. Certified mail. We have the receipt." And then she slid a document across to the clerk, and the clerk walked it to my bench, and I looked at it. The certified mail receipt. The green return card. The signature on the return card. The name of the person who had signed for and received that letter of notification 14 months before the eviction filing. I looked at the name for a moment. I looked up at Garrett. I said, Mr. Ellison, is your signature on file with this court from the initial filing documents? Clifford said, Your Honor, I'm not sure where this is. I said, yes or no, counsel? He said, yes. I said, I want the filing documents and this return receipt in front of me simultaneously, right now. There was a pause of maybe 90 seconds. My clerk is efficient. When she put both documents on my bench, I compared them for about 20 seconds. Then I took my glasses off and set them on the bench in front of me, which I have been told is something I do when something genuinely surprises me. And honestly, I didn't even realize I was doing it until later. Because the signature on that certified mail return card, the signature confirming that the property management company had received Marcus Tatum's written notice of the grab bar installation 14 months before they filed an eviction notice citing that grab bar as a lease violation, was Garrett Whitmore Ellison III's own handwriting. He had signed for the letter himself, and then his company had filed the eviction anyway. Let me tell you what that means in plain language, because I want to be precise. It means that someone at the Ellison Property Group, and the trail, as we would establish, led directly to Garrett, had received a federally compliant notice of a disability accommodation modification, had not responded to it as required, had waited over a year, and had then filed an eviction proceeding citing the very modification they had been properly notified about. Under the Fair Housing Act, that is not a procedural dispute. That is a federal civil rights violation. I called a recess, not because I needed to think. I needed to make a phone call to the Federal Housing Division office because what was sitting on my bench had just moved this proceeding somewhere beyond my original jurisdiction. Here's the thing. I've had cases that escalated mid-hearing before. It's unusual, but not impossible. What was unusual was the nature of what I was looking at. This wasn't a paperwork error. Paperwork errors don't carry someone's signature on a certified mail receipt. Those are intentional acts. When we reconvened, I had a decision to make about how to proceed. But first, I had something I wanted to say to Garrett Ellison directly, and I was going to say it while his father was sitting in that gallery watching, because what a man does in front of his father sometimes lands differently than what's said in any other room. I looked at Garrett and I said, I want to ask you something and I want you to think before you answer. On the date shown on this receipt, when you signed for this certified letter, did you read its contents? He looked at Clifford. Clifford gave a small, nearly imperceptible headshake. But Garrett, and I think this was the first moment in the entire proceeding where something in him slipped, he said, I probably did, yes. We get a lot of mail. I said, so you read a compliant notification from a disabled tenant, a veteran, and your company's response 14 months later was an eviction notice. He said there were other factors. The property was being repositioned. Market considerations. I said, Mr. Ellison, I'm going to stop you there. I picked up the laminated photograph that had been submitted as part of Marcus's evidence file. I hadn't mentioned it yet. I held it up. It was a photograph of 3 children, a girl of about 9, a boy who looked maybe 6, a small one, maybe 4 or 5. They were holding hands on what appeared to be a sidewalk somewhere in Afghanistan. Behind them, barely visible, was a younger Marcus Tatum in uniform looking back over his shoulder at the camera. The girl in that photograph. I'd been told. She was now 20 years old and studying to be an engineer in Kabul. The 6-year-old boy had survived to grow up. The 4-year-old had not. He had passed from unrelated illness 2 years after the incident. But 2 of 3 had lived. Lived because a 23-year-old kid from Decatur, Georgia, had run across open ground without thinking about what it was going to cost him. I set the photograph down and I looked at Garrett for a long moment. He was looking at the photograph. His face had changed. I don't want to overread a face. I've been wrong before. But what I saw looked less like guilt and more like the first time something outside his own life had actually registered as real to him. I said, the proceeding before us has changed in nature. I'm referring the federal civil rights component to the appropriate division. What I can address today is the following. I stood up. The courtroom got very quiet. Marcus Tatum was to be restored immediately to full tenancy, with all eviction proceedings dismissed with prejudice. The Ellison Property Group was ordered to pay $47,300 in damages, covering Marcus's legal fees, the documented costs of his housing instability during the dispute, and compensation calculated at the federal rate for discriminatory housing interference. The property management firm was ordered to undergo Fair Housing Act compliance training for all staff, the curriculum to be approved by a federal compliance officer within 90 days. Garrett Ellison personally was referred for a formal disciplinary review by the State Real Estate Licensing Board, with my written recommendation that his managing partner status be suspended pending that review. And I ordered, this part was within my discretion, and I exercised it without hesitation. I ordered Garrett to appear before this court in 60 days with a written statement, reviewed for authenticity by my clerk, addressing what he had understood and what he intended to do differently. Clifford Beaumont was writing very fast. From the first row on the right side of the gallery, Whitmore Ellison Sr. rose from his seat. The room braced. I've watched families in that gallery stand up before, and it almost never goes well. But what he said, and I'm going to get this right because the exact words matter, what he said was, "Garrett, sit down and don't say another word." His voice was quiet and completely flat. "You did this." And he sat back down. Garrett sat very still. The bailiff moved toward the defendant's table, but Clifford raised a hand and said they would comply fully and that no further disruption was intended. Garrett stood and straightened his jacket out of what appeared to be pure habit. The vacheron on his wrist caught the courtroom light. His heels, not quite designer but close, made a particular sound on the tile floor as he walked out. Erline Tatum didn't move. She sat in the gallery with her hands still folded, and when Marcus looked back at her, she gave him one small nod. That was it. Priya Vasquez picked up her file folder. She looked like she'd aged backward about 5 years since she'd sat down. Now, I want to tell you what happened after. About 7 months later, or was it 8, I'd have to check, Marcus Tatum had moved. Not because he wanted to leave his apartment, but because a veterans nonprofit in the county had connected him with a housing assistance program that got him into an accessible home with a small yard. His first yard, he sent my clerk a photograph of it, which she printed out and has had on her desk since. A small backyard, a lawn chair, a dog of some kind, gray and medium-sized, blurring at the edges from tail wagging, and Marcus in his chair with his face tilted toward the sun. The federal civil rights referral resulted in a settlement that I'm not able to discuss in specifics, but I can tell you that the Ellison Property Group's residential division now has a compliance officer on staff, a full-time position. I know because the woman who took the job called my clerk to say thank you, which I found both unexpected and appropriate. Garrett Ellison. He appeared at the 60-day review. His written statement was, look, I've read a lot of court-ordered apologies in my career, and most of them are thin. You can feel the attorney's hand in the word choices, the calibrated remorse, the strategic acknowledgement of wrongdoing that manages to avoid saying anything truly specific. Garrett's statement was different. Whether that was because his father said something to him or because something in that courtroom had gotten through in a way he hadn't expected, I genuinely don't know. What I know is that the statement named Marcus by his full name 4 times. It named the specific violation. It named the grab bar. It said, in plain language, that what had happened was wrong, and that he understood it was wrong, and that the word sorry didn't cover it, but he was saying it anyway. My clerk, whose job it was to evaluate authenticity, brought it to me and said, I think this one's real. She's been doing this 22 years. Her read is usually right. Garrett's managing partner status was suspended for 8 months. He returned to the company after completing the compliance training alongside his staff. His choice, not a court requirement. The attorney who told me this seemed surprised by it. I wasn't. People are more complicated than their worst moment, and if I believed otherwise, I'd have gotten out of this business a long time ago. Now, here is the number I want to leave you with, because I said at the start that there was something that became bigger than one case, and I meant it. In the 18 months following this proceeding, the federal housing referral triggered a review of 41 other properties in the Ellison Group's residential portfolio. That review identified 22 additional tenants, 22 who had received or were in the process of receiving eviction or non-renewal notices that showed procedural irregularities similar to what Marcus experienced. Of those 22, 14 had some form of documented disability or medical accommodation need. 14, a compliance remediation process that kept 18 of those households in their units. 18 families who stayed put. 18 front doors that didn't have to change. You want to know what justice looks like when it's working correctly? It doesn't always announce itself. Sometimes it shows up as a certified mail receipt with someone's own signature on it. Sometimes it's a grab bar on a bathroom wall that should have been approved 14 months ago and wasn't. Sometimes it's a man who lost both legs at 23 years old, sitting at a plaintiff's table in a dress uniform he ironed himself that morning, holding a photograph of 2 children whose names he still knows by heart. And sometimes it's a courtroom that goes completely silent while a judge takes off her glasses and looks at a signature because the evidence has just told her something she didn't fully know how to carry yet. I've been on this bench for 31 years. I don't have 31 more in me. But I'll tell you what I've learned. The thing I come back to more than anything else: accountability isn't cruelty. Given the right conditions, given evidence that can't be argued around, given a proceeding that doesn't bend to the weight of a name or a number, it can be the beginning of something. For the person who was wronged, obviously. But sometimes, if you're lucky, for the person who did the wronging too. That's all I've got to say about Garrett Whitmore Ellison III and Marcus Tatum and the grab bar that ended up mattering quite a lot more than $40. I've carried this one long enough. You can have it now.